We have saved one of the most fascinating, all the papers are fascinating, by the way. One of the most fascinating and so we have spoken about constrained natural language, ordinary language, but some people, and French philosophers, for instance, are very good in that, like to invent new languages and new vocabularies. Why do it with the old vocabularies? And developing a new vocabulary, relabeling things, means you're going to put a different lens and we'll see things differently and reconstruct the world that we navigate in. And this is, of course, extremely important because if you have a new lens, you might see things that are otherwise hidden. You might also not see things that are actually not so important. And we're now going to listen, and I'm immediately going to give the floor to somebody who's speaking to us from Brazil in a week that has been quite interesting, not only for Brazil, not only for Latin America, but I think for everybody in the world. So the floor is all yours, José Antonio Magalhaes. Am I pronouncing this correct?
Yeah, José Antonio Magalhães. Portuguese has a lot of weird sounds in it, so close enough. So shall I start? Can you see my presentation?
Yes.
Can you hear me?
Yes.
Okay. So from now on, I'm going to be seeing my own slides. It's a bit solipsistic, but I'm going to try to move through them within the 15 minutes. I'm going to start a timer here. And well, thanks so much for having me here. I'm really excited and a bit nervous to be exposing some of my research in a context where there is so much very advanced discussion being done about computational law. And well, my paper that I'm going to present today is called Platforms as Law, a Speculative Approach to the Study of Law and Technology. And it sort of summarizes a lot of results from my PhD thesis, which was in this same field. And I should say up front that I'm approaching this from a very theoretical and very philosophical, in a way, perspective, which I recognize doesn't have as much traction on the concrete technologies that are shaping the transformation of legal practices and legal institutions today. I think Professor Mireille's provocation yesterday is very important, and it's one that I don't know when and to which extent I might be able to respond. But here, what you're going to see is something that's quite abstract, and also when it gets concrete, it doesn't necessarily focus on the same technologies or the same legal technologies. And you see that is because I'm trying to problematize the very concept of what counts or doesn't count as a legal technology. But in any case, I see myself first as a legal theorist, and what I'm presenting here more specifically, I see it as a form of speculative legal theory. And that comes from the interface between legal theory and a group of contemporary theoretical explorations that you might know to different extents, but that I'm grouping generally under this title of speculative theories. So I'm working on the interface of those speculative theories that exist in the humanities and in the social sciences and in philosophy, and the question of law and the relation between law and technology. And I'm also like this kind of speculative legal theory also because of this type of theory that it draws from, it emphasizes a focus on the non-human sources and aspects of law. So mainly new technologies, which is the main focus of this presentation, but also, as you will see in the end, ecology and ecological problems and questions. And the context in which this specific research takes place is the hypothesis of contemporary process of the platformization of law, a becoming platform of law and a becoming law of a specific kind of platforms, data-driven algorithmic platforms that we are seeing today. And the big premise of what I'm calling speculative legal theory is that we do not know what law is. We do not know exactly what it is today because it has always been changing, and especially we don't know what it may or may not become. So as an overview, I'm framing my paper in the context of this code as law and law as code debate, which has been treated in various ways already here, and I think most of you know, so I'm going to skip recapitulating that part of the paper. And my main focus is to produce a legal concept of platform, which is to say a concept of platforms from the point of view of legal thought. And the main outtakes from the paper, I think, is that I present three kinds of norms that I think are involved in what I call platformnomics: coded norms, interfacial norms, and environmental norms. And at the end, and I don't know how much I'm going to have time to get there, I try to produce some concepts in platformnomics, especially those of device, application, interface, and user, and to explain how those relate to those three kinds of norms. So I start by contrasting two approaches to the problems of computational law. One is what I call legal correlationism, which starts from the presupposition that of this bifurcation, this distinction between norms as something that is human, cultural, and law is on this side, versus the world of facts, the natural world that is made of non-human entities, including technologies. In this approach, the idea of code as law is understood metaphorically. Law is understood metaphorically here, as it is often used with quotation marks. And then the question becomes how law, which is normative, can or must regulate technology, which is factual. Speculative legal theory is contrasts with legal correlationism, or tries to overcome legal correlationism by not presupposing the distinction between norms and facts. As a consequence, it looks at code, including computational code, as law proper, in a proper sense, and legal concepts are then applied directly to technology. I emphasize in my paper that this is not to say that preoccupations with protection of law as we know it, of its principles, of its affordances, is not important, but that it should be supplemented with speculation about what law might become. So on the one hand, you have to be able to emulate some of the affordances of text-driven law and have a degree of recalcitrance, but I think you also have to be able to explore the potential affordances of computational law. And then the problem becomes less of recalcitrance, but also of the navigation of contemporary technological and legal transitions. And I extract from that the idea that to think of law as something else is to make law something else. So the work of legal thought is also to create or to invent what law might become while it is becoming other from what it currently is. I try to offer a nomic concept of platform, and I start from the most basic sense of platform, which has been discussed in other discussions about platforms, which is a differentiation of levels. So you have a plane that is detached, that is abstracted in relation to another plane. And that applies to all kinds of different senses of the word platform. And specifically, a nomic platform, for me, is a plane of freedom that is afforded through the implementation of constraints on a lower plane, on a plane that appears then as a relatively lower plane in relation to the plane of the platform, which we might call the ground of the platform. And then I try to think of modern law as a platform and of platforms as law in order to be able to think this transition. So law as we know it is already first based on a form of coding, I argue, though it is coded through natural language, which is, as Professor Hildebrand and others have argued, ambiguous in contrast to computational code. But even with that failed, imperfect type of coding, it is able to produce a plane of norms in opposition of a plane of facts. And the determination of those norms, the disambiguation of those norms, and the application of those norms is operated through a series of modern legal technologies, not only text and writing and the codex, but also courts, the rights, the procedures, the interpretive techniques that judges develop and use and share, and also police technologies, institutional technologies of legal enforcement. And this is all also related to a modern conception of technology, which I would argue relates mainly to the idea of instrumentality, which is to say, of the idea that non-human or natural entities appear as means, while the kingdom of ends is purely the product of culture, which is to say of humanity. And law would be within this second domain. So here would be a diagram of modern law, the plane of law, the modern legal platform, and the ground of natural reality, the plane of facts. The transitions between those two are articulated through technologies of enforcement and technologies of institution and interpretation. Then platforms as law, and that's the context in which I speak of three kinds of norms. Coded norms, which are expressed now in computational code, which is to say in languages that are specifically developed to be unambiguous and then mechanically interpretable by machines. There are interfacial norms, which are the norms that manifest concretely to users as limits and possibilities of actions in different kinds of interfaces, user interfaces. And then there are environmental norms, which are a more subtle kind of norm that becomes intelligible in the context of algorithmic governance. But the difference here is that the distinction, the platformization, the detachment of the platform is not correspondent to the norm/fact distinction. It's rather a distinction between a platform and a ground. The platform, and it's not based on the norm-fact distinction in the sense that the platform, the platform's code-driven and interfacial norms constrain as a kind of physics, to use Lassig's formulation, and also the environmental norms emerged from the ground. So the ground also has norms. It's not correspondent to the purely natural or factual domain. So here we have a diagram of platforms as law. You have a platform stack that has various levels of coded and interfacial norms that are stacked upon one another. Those correspond to different levels of abstraction of computational languages, from more low level to more high level languages. And then you have the ground, which is the environment of the platform, and where you have the environmental norms. And the relation between those two planes is operated through what has been often called algorithmic governance. So algorithmic governance is how data-driven platforms interact with their environment. And they do that, and this has been discussed in the literature, for example, by Antoinette Rouvois. The algorithmic governance operates in three phases: the massive acquisition of data, the mapping of statistical correlations from that data, and then the use of this map to act upon actions on the social milieu, on the environment of the platform. through this process, I argue that there is an extraction of environmental norms which exist on the platform's environment, on the socio-technical, ecological milieu that the platform acts upon. For example, our lives, our way of living of humans and non-humans is populated by potential actions, virtual actions, not all of which are always actualized. So through algorithmic governance, it is possible to map norms that exist only virtually, which is to say, rules of conduct that have not been actualized, that exist on the milieu, and then act to actualize those conducts, to produce them, to bring them forth into action. So that is I argue that is a kind of norm and therefore an object for legal theory. So in algorithmic governance, norms in this sense are not imposed from the top down, but found in the environment. So this makes algorithmic governance a sort of very soft, very subtle, very tricky kind of governance, which doesn't mean to say it's not insidious or that it's not bad. And here I'm talking about environmental norms specifically. Coded norms and interfacial norms are something else. But then finally, and I'm already reaching the end of the time, I offer those concepts in platformnomics. I think maybe we might be able to discuss them more in the discussion if there is interest. Especially, I would like to know the impression of people more involved than I am with technology, if they think this maps those normative concepts map out with the technological counterparts. But well, I'm going to skip this last part about devices, applications, interfaces, and users, and then this idea of the transindividual user, simply because of lack of time. But my last point would be that we are exploring this possibility of a reciprocal becoming law of platforms and becoming platforms of law, and that we need legal concepts to navigate such transitions. So I ask whether we can actually tell whether this is a risk or an opportunity, since it's still underway. It's a transition that is still underway, and especially if in the era of climate catastrophe, whether a law that is not based on the norm-fact bifurcation is necessarily a bad thing. I think we have to explore potentials that might be useful for us in problems that are also new, that are as new as these new technologies for us as a species, as societies, and all that. Of course, that doesn't mean that platform governance currently is good. I think it's very clearly going in very bad directions in many senses. So I think we have to ask, what is wrong? Is it the technologies? Is it the worldview, the Western worldview that is accompanying those technologies? Is it capitalism? Is it greed? Is it a moral problem? Is it a political problem? That's something that, of course, I can't answer in the context of this presentation. But anyway, I would like to thank you. And if you want to follow me on social networks, as I saw that people are sharing their Twitter, even though that network is also going through weird transition right now. Well, thank you very much, and I very much look forward to discussing this with everyone.
Thank you very much. And the floor is now to Cecilia Rikap, who is going to reply. And please, could you introduce yourself first?
Sure. First, thanks a lot for the invitation, for the chance to be discussing with you. I am, for just a bit of a background, I am an economist. I did a PhD in economics. I work as a political economist. Although I was trained as a more mainstream economist, I always had a deep heterodox economics, not only background, but also eagerness of understanding. And it is through that as well that I, during my postdoc and at different moments in my career, I also got familiarized with science and technology studies. And I also work with different colleagues trying to build interdisciplinary understandings of contemporary capitalism, in particular, of forms of corporate power, and with a focus, among others, on digital capitalism. So my discussion and the questions I'm going to pose to Jose and to all of you there are coming from this background. I am nowadays a lecturer in international political economy at City University of London, where I am right now. This is my office. So I have already prepared some thoughts and comments and some questions based on the long abstract that Jose prepared for this conference, but I also have some remarks based on his extremely insightful presentation. So I will go first to discuss more a bit about the long abstract. And from my perspective, what I see is that your piece tries to elaborate on platforms as regulators, platforms as rule setters. And indeed, there is a wide literature on political economy, for instance, on platforms not only as digital infrastructures that are connecting users, but also as organizations or businesses that are creating those connections. And to that end, they use both technical, discursive, as well as formal protocols to precisely set their own terms. So in this respect, I think that your research is establishing a lot of dialogues with these other ideas. I nonetheless have, during my own research, I have been arguing that there remains an aspect that is under-theorized in this understanding, which is, of course, platforms are all this, but on top of that, and here I will be speaking, for instance, in particular about big tech, we could summarize this blind spot as a question that argues, what is it that has enabled big tech companies or platforms in general to build such infrastructural cores, to become rules or become rule setters, and to be, even to some extent, monopolizing essential digital services? And even building on what you said, Jose, what has enabled platforms to become law in your terms? And this moves us from the platform as a quite fuzzy entity, because as you may already know, for some platforms are the structures, for other platforms are the companies. So one of my questions would be along these lines for you in 1 second. But again, I think this moves us to the more concrete discussion about how rules are being controlled and developed by certain firms in the digital environment, in particular by big tech companies from the US and China. And they do so by using algorithms as rules. Algorithms have always been a form of a rule and that organizes and shapes behaviors. And these companies are using them in a specific way because the algorithms that they use are algorithms of machine learning, in particular of deep neural networks, which learn as they process more big data. So this technology package of big data with algorithms that are not just algorithms set once and for all, but are always being updated and changed, can actually be thought as the specific ways in which these companies are setting rules. And this leads me also to what they are ruling or who they are ruling. And if we think, for instance, of the cloud, in your long abstract, you made a reference to the cloud, but perhaps I missed it in the presentation, but you didn't mention it now when you were discussing it in live. And the cloud is a platform that is way different from just social media or other platforms, because it's a way in which organizations around the world at the same time use technology without really accessing that technology. So they become technologically dependent. They rely on the black boxes, on these codes, on how to do things without knowing exactly how those things are being done. And to some extent, they become blind followers of what this code encapsulated in black boxes is telling them that will happen or how things should be working. So besides all the political economy dimension of this and the consequences in terms of firm subordination, the other dimension is that when we think of platforms as law, again in your terms, I think that we should distinguish between different types of platforms, and we should think about how heterogeneous companies that operate platforms are at the same time. So I wonder whether platforms also is the best possible unit of analysis, and also because it uncovers, as I'm saying, many realities. And let's think for 1 second, thriving and struggling platforms, do they set rules, or are they law in your terms again, as in the same way? As I was saying, the cloud is a very special case, and the scope of the ruling will also be different depending on the company. So there is also another dimension, which is corporations as rule setters, and the different ways in which corporations establish norms or ways of proceeding. And this connects back to whether I tried throughout my comments to avoid using myself the term law. And this perhaps is my bias from where I come from, because for me, laws, or if I think of the law, I think of the law in two main ways. So I think of laws in sciences, for instance, that are aimed at being universal. So the laws of nature, or the gravitational law, or Einstein's relativity law, that kind of way of using the law as something that is universal. And in fact, the rules that platforms are setting, because of the way they analyze data with AI algorithms, and you mentioned this in the abstract, if I'm not wrong, actually have a capacity to personalize rules. So no longer think in terms of a universal law that applies to every single case, but actually specific rules or specific ways of making individuals and organizations behave in certain ways. And also, the other reason why I prefer to speak of rules than of law is because when I think of law, I automatically associate it, and this again is probably my bias from where I come from, so I'm very much looking forward to hearing what all of you think about that. When I hear the term law, I think of the democratic laws that are approved by democratic governments, whereas rules is more general in that respect, and enables us anyway to discuss about who sets behaviors, how they are set, and so on. So just to sum up and wrap up, if we think of this in some extent encroachment process where platforms are law, and therefore who's setting those laws and what's the role of the state in that context, for instance, I think, and also at your presentation, there were some moments, for instance, when you were speaking about the duality, basically between the social and the natural, I tend to think of that from an action network theory perspective. So actually thinking that there is no possible way of conceptualize or of thinking of the world as different entities that come together, but actually as actors that are reshaping and reconstituting each other constantly. And this is something that I've been, for instance, studying for the case of big tech with states, with core states, what are the competences of a state, what are the expected behaviors of a firm are changed by their mutual interaction. So I was wondering, with all these comments, first, what do you mean by platforms? Are you speaking of the companies? Are you speaking of the structures or something else? Why platforms as law and not as rules? Or whether you see a difference between the concept of law and the concept of rules, and also why platforms and not the algorithms as the rules, and the platform structure as the way or means of enforcement of those rules. At least this is how I think about them. And also the platform corporation and the artificial intelligence in an intertwined way setting those rules. And final question, what do you think is different about the cloud? Just again, because you were mentioning some things about the cloud in your long abstract. And final question, just because of something you said in the presentation, you said that you wanted to contribute to building a legal concept of platform. And I wonder, do we need a legal concept of platform, or do we need a powerful concept of platforms that builds on and also overcomes disciplines? So of course, we'll build on legal scholarship, and also on political economy understandings, historical understandings, and so on and so forth, but actually will integrate them all in a more powerful concept to conceptualize the world in where we are contemporarily living. And yeah, thank you again very much for the opportunity to discuss your research.
Thanks so much for your feedback and for your questions. I mean, there's a lot to address here.
Hello.
Can you hear me?
Hello, I need to apologize because I have checked and I have not sent Cecilia the paper. That's a big mistake because she's now responding to the extended abstract and your talk. Well, you have explained all this in the paper, of course. So I want to apologize and to note that she has not seen your paper. So it might help to go into the last part of the paper that you have not discussed in the presentation while answering her questions. And again, my fault.
No worries. I hope we get, further opportunities to discuss the paper at more length. Even without the paper, there's already a lot to address here. So, well, let's get to it. So to start with those questions that you formulated more directly at the end, but then I'm going to try to address the other questions that appeared throughout your intervention. So do we need a legal concept of platform? I think there are two different approaches that can be taken here, and I don't know if there's a way where I could say that one is more valid than the other, but I tend to think that as we are coming from a context where we have a variety of disciplines, which is to say a variety of paradigms, of methodologies to construct knowledge and to construct approaches to reality that have different traditions, that are different genealogies and different realities. I don't think, especially in our context today, that what differentiates those approaches is their objects. I think what differentiates those approaches is more how they construct their objects. But that being said, I think for me, the most interesting way of being cross-disciplinary or transdisciplinary or multidisciplinary is to have objects constructed or approached through a multiplicity of perspectives. So you can sort of construct a kind of a cubist image of the object, and I think that applies to the platforms. I don't think that the legal concept of platform is supposed to be the best way to approach platforms, but the only reason why I am trying to provide a legal theory of platforms is that I am a legal theorist. It's not that it's special in any other way, but I think it's important in a specific, in a singular way, and that has to do with, for example, if you compare a legal approach to a technical or technological approach or a scientific approach. With a legal approach, you have dimensions of fairness, of democracy, of justice. You have a bunch of problems that are not capable of being posed through all different approaches. So, of course, there are other political and sociological and other approaches that can be normative as well. So, of course, you could have a sort of a synthetic approach to try to make all those approaches into one synthetic approach, and that is legitimate as well. It's just not something that I'm trying to do here. What do I mean by platforms? I try to say it there. I have a very broad concept of platform, a very broad nomic concept of platform, which is simply when you differentiate, when you produce a difference of level where you have freedoms that are afforded to certain agents through the implementation of a certain organization of constraints on a lower level or on the level that appears to the platform as the ground. Why platforms as law and not as rules? I think I see law as made of rules. So for me, it's not necessarily that much of a problem. I mean, there are rules that are not considered legally when they are technical, when they are instrumental, or there are kinds of rules that are not considered as legal rules, but then I'm trying to understand platforms through legal conceptions of rules, though I'm not using the most strict conception of an abstract auth. That's also why I bring in the concept of nomos, which is this Schmittian concept that tries to think of law as something that is not constructed through this bifurcation of nature and culture, so or of facts and norms. So in that sense, I see the possibility of concrete rules, which, for example, appear in the case of interfacial rules. And I try to conceptualize all of that as law. Regarding the question of whether algorithms are rules, I think one important point that I'm trying to make by making those differentiations of kinds of rules that exist in platformnomics is that we can be misled by the idea of algorithmic governance copulated with the notion that algorithms are rules, and they are what I'm calling coded rules. You're of course right to say that, but at the same time, I think that what characterizes algorithmic governance and what we are calling algorithm in the larger, social political discussion today doesn't have that much to do with the coded rules that make the algorithms. What is actually new, both in relation to modern law and in relation to previous types of even computational technologies, is not the code, is not the algorithm, it's not a series of instructions. It's the way this is used with machine learning to interface with the platform's environment and extract environmental norms. So I think that algorithmic governance is precisely not governing through the kind of rules that we relate to algorithms. It is governing through rules that exist potentially on the platform's environment by actualizing those rules through the use of other kinds of rules, and these exist on the platform, which are coded rules and interfacial rules, or coded norms and interfacial norms. I'm not making a distinction between rules and norms. I just prefer norms for some reason. I think rules makes me think of abstract rules more than norms. So are platforms the best possible unit of analysis? I don't think necessarily. I mean, it's just the unit of analysis that I'm using. So there are something, and I'm using platforms on two different levels of abstraction there. So there's one sense in which I'm saying that anything that produces a difference of level is a platform. There's a way in which I'm saying that everything that produces a normative difference of level is a nomic platform. And then there's a sense in which we have a specific kind of platform, which sometimes I call algorithmic platforms or data-driven platforms or tech platforms or cloud platforms, which are a family of contemporary, generally private, capitalistic enterprises, but also technological assemblages that are gaining very rapidly a very big importance in the governance of human and non-human conducts on the planet. So that's why I am focusing on that. And to say that all of those are platforms, I try to approach that not as a general category, but as a paradigm, in the sense that you can compare this idea, this concept of platform that I'm offering to different instances of platforms and see what they have in common and what they have as their differences. So I think there are, of course, many specific studies that can and should be done. You could, map out the nomic character of Amazon as opposed to Uber, as opposed to Google, as opposed to specifically legal in the sense of relating to legal institutions, to traditional legal institution, and see how all of those are different, and that should be done. It's just not something that I am doing at this point. I'm on a level of abstraction that doesn't focus on the differences between those platforms.
Do I have questions in the audience? Yeah, Tatjana.
Hello, José. I think it's working. Olá. Boa apresentação. So I have, think, 2 questions. So I think first, your work is very courageous because you challenge us to think in different terms. But I think, as you call it, you qualify your position as speculative, which in my understanding is something indicates that there's no assumptions, or at least the fact norm opposite binomial, it's not there. But what I find a bit intriguing was that you qualify as technologies realities like courts or police, and I think I lost the institutional part here. So what do you think technologies are? So what is actually the concept of technologies? Because a lot of different realities are there. So courts, practices, police. So it's strange for me to see it as a bunch of technologies. But maybe even more intriguing than this one, you talk about human and non-human users of the platform, so to speak. So I wonder, evoking the law as a legal protection or as aimed at legal protection, why are we caring about non-human realities? So what are we protecting, or what are you aiming at? And regarding the title, and like last comment, like picking up on the rules, norms, vocab, I think would be less problematic if you talk of platforms as normative rather than as law, in terms of the criticism you might receive. Because I think it's less problematic talking about a normative, and you like the term normative, rather than law. I think it would spare you some issues of language and criticism, I would say.
José.
Thanks so much. I'm getting okay. So yeah, I don't use speculative as meaning that I have no assumptions, at least not consciously, though I think it has to do with that. I mean, I mean speculative in both in the sense where these contemporary theories are sort of trying to distance themselves from the Kantian presupposition of the subject-object correlation and the transformation, the consequent transformation of all problems into epistemological problems, and trying to get back to the things themselves and what that amounts to in the case of law. And also that has to do, as I said, with not being based on the human/non-human distinction. And then in terms of the protection of non-human realities, there is a sort of political or cosmopolitical, to use Isabelle Stinger's expression, commitment in that, because I think, as I mentioned at the end of the presentation and of the paper, that the context of the Anthropocene and of climate change makes it very important for us to be able very quickly to change the way humanity as a whole is operating on this planet and in relation to non-human agents. And I think from the perspective of law, one very important aspect of that is to understand that ecological systems are normative in a way. And you have, for example, Margaret Davis, who is a legal theorist working with this. She has published a book this year called Eco-Law, in which she starts with Canguilhem's work to describe normatively those ecosystems. So I think that algorithmic platforms, in as much as they can extract norms from users without depending on the modern construction of the legal person as specifically human, it can help us to understand and to enforce non-human normativities, which is to say the norms that are implied in the organization of the biosphere, so to speak, as valid legal norms in themselves. We would be able to extract them. I mean, that is something that is still quite, it's not something that I've been able to work through sufficiently, but it's a direction of integration between those two dimensions, the technological and the ecological concerns. And then about discussing platforms as normative and not as law, I mean, maybe that would be less polemical, but that would also be less interesting to me. And as I said, I'm a legal theorist. I'm not a normativist media theorist. I'm not a theorist of technology that wants to argue, as probably many have, that platforms have a normative dimension. So yeah, for me, and that is the point of the whole paper. I mean, for me, it's a legal problem.
Okay, thank you very much.